Good afternoon, Judge Unterhalter.
Good afternoon.
How are you this afternoon?
I'm very well. How are you, Chief Justice?
I'm all right. Thank you for once again availing yourself for consideration for appointment to the Supreme Court of Appeal. I'm not going to repeat the rules that we follow in these interviews because you know them so well by now.
Indeed.
So I will ask you questions, and then I will allow the president of the SCA and thereafter the minister and the commissioners. We will all be trying to just satisfy ourselves to what extent you meet the selection criteria that we have adopted. But you have been here, what is the fourth time now?
I think so, yes. I think that's right.
Yes, so we know you quite well, but we still have a lot of information on you that you have supplied in the questionnaire and other documents. So we won't try and cover everything that's in the documents because everybody is deemed to have read what's in the documents. We'll just focus on certain matters on which we would like to hear you. Your academic qualifications are BA, LLB, MA, and BCL. Is that correct?
That's correct.
Yes, and the universities are Cambridge, Wits, Oxford, and Cambridge.
Yes, that's right.
That's right. And you were in the academia before you started practicing as an advocate, is that right? And when you were practicing, you were also partly teaching as well.
Yes, I had a stint in academia, and then whilst I was practicing, I also was an academic. And then I went into academic. I then became the head of CALS, and then I went back into practice. But I continued my academic career whilst I was at the bar.
Yes. If I remember correctly from last time you were here, I think we said you had practiced as an advocate for, is it 27 years? Or
27 years.
27 years, yes. And would you like to just share with the commissioners once again the different branches of law in which your practice was involved?
Yes, well, I had a spread of competences in my practice. I did a fair amount of commercial law, I did a lot of public law, and I also did numbers of more specialized forms of regulatory law, particularly competition law and aspects of trade law. So I also had some dealings with intellectual property law. So that, in general terms, I suppose, was my practice.
Yes. And during the time when you were practicing and teaching, you published numerous articles which are listed in the questionnaire and the annexures, and you also got involved in writing of some books as well, isn't it?
Yes, it was part of my academic work that required academic writing, and I've listed those publications.
And there's a long list in the documents, And during that period of 27 years in practice, is it true that there were, is it over 300 reported cases in which you had appeared in the various courts?
I haven't done a counting, but I appeared many times in many of our courts, and there were many reported judgments.
Yes. I'm sure. I'm sorry for that. Well, I remember having a look at the last interview. The list was certainly not less than 100.
No, I think it was in excess of that.
Yeah,
So yes, there were hundreds, I think.
yeah, yeah. And you were then appointed as a judge of the High Court, is it about 6 years ago?
Yes, in 2018. I commenced in 2018.
Yes, yes. And over the period, you have written numerous reported judgments as well, is that correct?
Yes, I think a little in excess of 50 or
Yeah.
something more, I think, yes.
Yes. And would you like to share with the commissioners the different branches of law in which you have written judgments as a judge of the High Court?
Well, I've tried to list some of the more important ones in my curriculum vitae, but they include judgments in commercial law, in various aspects of public law. There are certain judgments on intellectual property law. So there are some criminal appeal matters as well. So a fair range of the kinds of judgments that one gets, as well as the law of delict and the law of contract. The High Court is a court of general jurisdiction, and so one gets cases from many areas of the law, and that's part of the challenge for being there. So, yes, those are some of the areas.
But don't do yourself a disservice because the purpose of the question is just for you to show the breadth of your experience. So
Yes.
there is insurance law, there is patent law, there is trademark law, there is customary law, and commission law.
Yes.
Just feel free to
Well,
mention them.
Yes, well, I think that, there are various areas in the law of contract, various areas in the law of delict, in particular, numbers of reported judgments concerning some of the more conceptually difficult parts of the law of delict around pure economic loss and how to think about it and its relationship to the law of contract. There's company law, where I wrote a long judgment in the Steinhoff case about that particular cause of action. There have been numbers of cases in public law and constitutional law. I had a long practice in constitutional law as our constitution developed, and I've sought to take some of that up in my judicial work. So I think across quite a large range of public and private law areas, you can see that I have offered my views in numbers of judgments.
And when you acted in the Supreme Court of Appeal, are there any branches of law that you got exposed to which you had not been exposed at High Court level?
Well, I think one of the things about the Supreme Court of Appeal, and certainly that's where I got exposure to, in particular, intellectual property law, which I'd had a little bit of exposure to in the High Court, but much more of it in the Supreme Court of Appeal, and tax law as well, which, forms part of the steady diet of the Supreme Court of Appeal, as well as, of course, the many public law areas that come, some questions on liquidations and insolvency. So it certainly broadens the scope of the work that I've done.
But you also acted in the Constitutional Court for 2 terms or so, is that correct?
Yes, that's correct.
Yes. Would you like just to share with the commissioners your understanding of the doctrine of the separation of powers?
Yes, certainly. The doctrine has 2 basic components to it. The first is that the 3 spheres of government are separate. And the second aspect of the doctrine is that the separation, however, also involves checks and balances, which is why it's a doctrine that has seemingly opposed component parts to it. Every constitution has its own doctrine of the separation of powers, and precisely how these components interact with each other is really an ongoing form of analysis. As our courts have said, South Africa has a distinctive doctrine of the separation of powers. but it manifests itself in different ways. One of the features that is obvious about the Constitution is that although it entails checks and balances, it also entails obligations of cooperation. And so in our constitutional order, it's addedly complicated because separation actually also requires cooperation. And so we have a somewhat unique blend of constitutional features that makes up our separation of powers.
Yes, and then the rule of law.
Well, the rule of law is a founding value of our Constitution. Currently in many debates, the rule of law seems to be able to encompass almost everything that anyone ever seems to want to say about law. But if I could distill perhaps three things that I think are fundamental about the concept of the rule of law. The first is the notion of equality before the law. The second is the supremacy of law, and in our case, the supremacy of the Constitution. And the third is the independence of the judiciary. Now, some of these concepts obviously, again, interact with each other, but I think a constitution that lacks those essential features is a diminished form of a constitutional expression of the rule of law.
Thank you. President of the SCA.
Thank you very much. Good afternoon, Justice Unterhalter.
Good afternoon, President.
Yes, you have had a number of acting stints at the Supreme Court of Appeal.
Yes.
How did you find the environment overall throughout, from your first stint up to the last? I think your last one was in November, right?
Yes, that's correct.
Yes.
Well, obviously, in joining and coming into act in a new court, there are many things to learn, both about how the court works and what are the ways in which colleagues engage one another in that court. But I think that I relatively quickly became accustomed to the ways of the Supreme Court of Appeal, and as time has gone on, because I think I've now had, about 10 acting stints in the Supreme Court of Appeal, I think I know its ways reasonably well. I've come to greatly appreciate the value of my colleagues there and the manner in which the court operates and works. And I've sought to work hard and be a productive member of the court. And so I would say that in general terms has been my experience.
Yes, you made reference to colleagues, so I'll ask you this question. Do you think that collegiality is an important aspect of being a justice of the Supreme Court of Appeal, given the fact that we only decide our cases sitting in panels, sometimes 3, sometimes 5, but you are never alone? So do you think that collegiality is important in that sense?
I think it's indispensable, both in the formal sense that in order to get the work done, one has to and must engage with one's colleagues for the purposes of preparing for hearing and then deciding cases. But collegiality is just as important in the more informal ways in which colleagues must respect each other, be open to persuasion by one another, and be able to assist each other when the need arises. And my experience of the Supreme Court of Appeal has been that is a court marked by its collegiality, both formal and informal. So it is, I would say, indispensable.
Yes. Have you ever had any issues with colleagues in any way in your 10 acting stints?
I've never had any problems with any of my colleagues, none that have ever been referred to me or none that they've ever raised with me. I've always endeavored to have a very open, engaging and friendly relationship with my colleagues, to help where I can and to be helped when I've needed assistance. There have been occasions where a colleague suffered some ill health, and I stepped in to be a member of that panel. And another occasion when a colleague was overburdened with many judgments, and I took on an extra judgment to assist. These are just examples of what all members of a court do to assist one another to make the court work. So I've never had any difficulty with collegial engagement, to which I attach a high value.
Have you at any stage delayed your own judgment or contributed to the delay of another colleague's, the handing down of another colleague's judgment, for example, by not submitting your inputs timeously or delaying to accept suggestions from other colleagues?
No, I think my record is that I turn in my judgments promptly. I try to adhere to the norm that I understood when I came to act in the Supreme Court of Appeal, that one tries one's level best to get one's judgments out by the end of term. That's not always possible for a variety of reasons. But I do think that it's important to try and adhere wherever possible to time limits in respect of the production of judgments. There are, one has to recognize occasions where, because judgments are the product of persuasion and engagement, sometimes colleagues have opposed views at one point in time, and then it takes some time to think about these matters and bring ideas together. And sometimes a dissenting judgment can turn into a collaborative judgment with a colleague. Those sorts of instances can sometimes take longer, and I can think of 2 instances where I've been party, I haven't been the main scribe, but I've ended up as party to a concurring judgment, a joint effort, where those judgments took a little bit longer, but it was a process of engagement to get to what we thought was ultimately the best answer.
Yes. So you are obviously aware that the Supreme Court of Appeal has experienced a loss of expertise and experience due to the retirement of judges and elevation to other courts, and amongst other things, hence the existence of these 3 posts. So would you agree that given the amount of experience that is lost, it would be crucial to replace such colleagues with equally experienced colleagues, both in terms of judicial experience and overall skill set?
I think it is critical. I mean, one of the things that one benefits from enormously in coming into a court like the Supreme Court of Appeal is the guidance and assistance of senior colleagues. That is just critical to the way in which courts work. When one loses some of that experience, one needs to try and supplement it as best one can. And so, yes, I think experience and expertise is at a premium for the court, and it's good working.
Yes, I'm just curious, looking at your CV, I noted that you have been a lecturer for quite some time. In fact, up until now, you are still a part-time lecturer at the University of Cape Town, is that correct?
That's correct, yes.
Yes. Which courses did you lecture on over the years?
Well, over the years, I've taught in quite a lot of different areas, but I started off life in jurisprudence, but then I've taught in public law. I've spent a lot of time teaching in competition law, international trade, and various other aspects of public law. So, and I currently assist in the master's program in competition law. So I've covered a number of areas.
Yes, I note that your overall experience as a permanent judge and your experience prior to elevation to the bench spans around 40 years or so. Is that a fair estimate?
It's aging me enormously, but it is true. I think it comes out at 34, but still, it's a lot.
Yeah, okay. Oh, well, prior to the bench is 34 plus the bench, 6 years total,
Indeed.
40 years. So, Justice Unterhalter, what would you say is the special attribute that you will bring to the table at the Supreme Court of Appeal in terms of complementing the existing expertise at that court?
Well, I think I've been privileged in my practice to have had a very well-rounded exposure both to many aspects of commercial law and many aspects of public law. And while the variety of cases that come to the SCA is such that no one can possibly have expertise in all of these matters, and I recognize areas where I don't have much experience from my days in practice, I do think that I have a lot of experience across many areas of law that are of relevance to the Supreme Court of Appeal. And I think that that really does help, because although you can work up a case when you don't have experience in the area, knowledge of the area, it obviously takes more time to do so. And if you know your way around the doctrine of restraint of trade and the like, you can just get to the issues more quickly, and that means that you've got a bit more time to deal with your workload and work efficiently and get to the issues and hopefully assist others in the court as well as in respect of your own work. So I think that's one of the things I hope to contribute. The second is that I think in the course of working in the SCA and in the Constitutional Court, as also in the High Court, I work hard and quickly to try and produce results, and I'd continue to try and do that in the SCA.
Thank you, Justice Unterhalter. Thank you, Chief Justice.
Minister?
I've got no question, CJ.
Thank you, Minister. Commissioner Marmohai?
Thank you very much, CJ. Good evening, Judge.
Good evening, Professor.
In your introductory remarks, you referred to, or you said something that is quite true, that the law of delict, it is one of those areas that are a little bit problematic. And I want to use one of your judgments to ask you just a general proposition. It is the judgment that is found in page 362 of the bundle.
Perhaps you just give me the name of the case and now.
It is Van der Bijl.
Oh, yes, I know the case.
Yes, Van der Bijl versus Featherbrook Estate. Yes. In paragraph 17, you say the law of delict has been principally concerned with liability for injury to persons and property. In other words, this is where you start dealing with the elements of the law of delict. I have recently found out that the elements of delict are not as straightforward as we teach them in the classroom, like for LLB. That there is this somewhat overlap between wrongfulness and negligence to some extent.
Yes.
I just want to hear your view on that possible conflation between the two elements and the role that they play in trying to make us understand liability in delict.
Well, I was very fortunate to be taught delict by Professor Boberg, and I was always told that the cardinal sin of that you could commit in the law of delict was to confuse negligence and wrongfulness. So I'll try and be a good disciple of the person who taught me the law of delict. But I think essentially, wrongfulness is concerned with various ways in which we might seek to impose obligations upon parties for civil wrongs. And negligence is a mediating doctrine, which says, well, we are not going to, except in very rare circumstances, allow our conception of what is wrong from the perspective of civil liability to be unmitigated by some concept of foresight. And I say other than in a few instances, because there are certain instances of strict liability. But I do understand that however one casts this language, the notion of duty of care and how that duty manifests itself, for example, in cases of pure economic loss and the like, which is what the Van der Bijl case was concerned with, so often seem to shade into kind of moral judgments around, well, if they could foresee this harm, why shouldn't I impose liability? And I think that's sometimes where these crossovers come about. And even though I think there's conceptual separation, I can see in terms of one's sort of thinking around whether there should be liability or not, but sometimes these concepts seem to bleed into each other.
No, well, you answered me. Thank you very much. Thank you very much, CJ.
Thank you very much. Commissioner Mangena.
Thank you, Chief Justice. Good afternoon,
Good afternoon,
Judge
Commissioner.
Unterhalter. My question relates to the issues that were raised by Professor Dendi.
Yes, yes.
And we were told that you were offered an opportunity to deal with that aspect, and you indicated that you will deal with it
Yes.
in this hearing. The Chief Justice asked you a question relating to the rule of law,
Yes.
and you answered that the rule of law is a founding value of the Constitution.
Yes.
And you would also know that part of the rule of law is that it establishes certainty and predictability amongst litigants and members of the public. With that said, why did you find yourself not bound by a judgment of the higher court, the Supreme Court of Appeal, in this case of DeBrain versus Steno?
Yes. Well, I of course read what Mr. Dendi had to say in his complaint, but I'm afraid I can't agree with the basis upon which he makes the complaint, because I reread very carefully what I said in DeBrain, and I reread very carefully what the Supreme Court of Appeal said in the Children's Resources Trust case. And if one pays close regard to paragraphs 38 and 39 of the Children's Trust, two things seem to be very clear. The first is that the notion of what is a tribal issue for the purposes of certifying a class action include the concept of an exception. So what I had found in DeBrain is that in order to determine what is a tribal issue, one could, as a court considering certification, determine whether there was a good cause of action as a matter of law, and that there was no reason why the certification court shouldn't decide that matter. And if it did decide that there was no cause of action in law, it seemed very difficult to see the basis upon which certification could be granted. Now, when one has regard to the Children's Resources Trust, and in particular paragraph 38, the Supreme Court of Appeal essentially said the same thing. And not only, I'm afraid, I think contrary to Mr. Dendi's view about this, what the Supreme Court of Appeal said is that often the certification court will have more information than a court would have on exception, because there is evidence as well as a draft set of pleadings. It's true that in paragraph 39, the Supreme Court of Appeal said, well, certification doesn't mean that an exception can't be raised later, but it didn't mean by that that exception proceeding or something akin to exception would not be relevant for the purposes of determining a certification. So I think I spent a fair amount of time in DeBrain thinking very carefully about what the Supreme Court of Appeal had said, and indeed what the Constitutional Court had said in Makadam, and try to give my best interpretation in fidelity to the Supreme Court of Appeal, not in opposition to it. Now, I may have interpreted wrongly, but what I was trying to do was to be faithful to the courts, not to be oppositional to them. And if I could just say one final thing, because I have obviously given this some thought. If the Commission has a look at what I had to say in the Capitec judgment, in that case I spend a good deal of time explaining why our law has changed in respect of the parallel evidence rule and how we interpret contracts, and showing fidelity, again, to the Constitutional Court in the manner in which extrinsic evidence becomes admissible for the purposes of showing what the purposes and context of a judgment should be, even though it's an expansion of what would ordinarily have been the case. So I think that the criticism that Mr. Dendy has offered is one I just can't agree with on my own analysis of the matter.
So in brief, you support the the correctness of the stare decisis.
Absolutely.
Yes, and you've got authority to beg you, because in another case, TWK Agriculture Holdings
Yes.
versus Wachfeld, you did come out strongly in support of that principle of stare decisis on paragraph 20 of that judgment.
Yes, in that case, I reflected on what it was 100 years of authority in the Supreme Court of Appeal, starting with Innes CJ in the Blauklippen case. And I said that essentially there were good reasons to continue to follow what had been said in that court for 100 years. Not everyone agrees with me, but that's what I said.
Thank you. Chief Justice, with your indulgence, this is my last and final question. It relates to the costs in Steinhoff.
Yes.
Right, it's a long judgment, but right at the end, you dealt with the question of costs in a single paragraph. And you predicated the funding, the litigation model. And I couldn't understand why you ordered people that you found to be poor litigants to pay costs.
I'm afraid you find me without recollection as to precisely what my reasoning was in a very long judgment around costs. I'd probably have to go and look at how I came to that. I think, and this is only from recollection, because I unless we spend some time, I'm not going to be able to immediately remember. But one of the features of that case was that this was funded class action litigation. One of the controversies in the case was precisely who the funders were and how they were funding the litigation. And I don't say that that was my reasoning, but it occurs to me that this wasn't seeking to impose on poor people who couldn't afford litigation costs, but it may well have been that because it was funded litigation. Class actions become our business in the world, sometimes for good and sometimes not. And this was a funded piece of class litigation.
Thank you, Chief Justice.
Thank you. Commissioner Singh. After Commissioner Singh, I've got Commissioner Makwanishe and then Commissioner Jodovu. Thank you. Commissioner Singh.
Thank you very much, Chief Justice, and good evening, Judge Unterhalter. I'm on the virtual platform this evening.
Good evening.
I trust you can hear me. Judge, during the 6th term of Parliament where I serve, we have seen 2 judges removed from their posts, which was the first time in our country's democratic history that this has happened. And consequently, public trust in the judiciary has suffered. How do you propose public trust in our own judicial system be restored? And here I also want to refer to the letter of objection where there were some allegations from Mr. Eric Akucho. If you can just tie those 2 in and then give us your view on that. Thank you, Judge.
Well, I think there are 2 ways in which...
Just interject on this, because, we got taken to task precisely because of this issue. The objection of Mr. Ochuko was considered by the JSC in the last interview. It was also considered at the JCC. On both occasions, it was decided by the JSC to reject it. And it was also decided not to put to the candidate. So this is the kind of thing where we get to take them to task because we are not following our own rules.
Yeah. Commissioner Singh, you get reminded.
I heard that from the Commissioner, Chief Justice, but I believe, it will not be a problem if Judge Unterhalter has to repeat, his complete denial of the allegations. I think that's good for the public as well.
Well,
But I just want,
if,
how do you
if we have
propose
agreed
the
that
public-
we won't proceed with it, if we have agreed, I think we should stick to that agreement. Commissioner Singh?
Well, I'm not aware of such agreement, but if you say so,
Well-
Chief Justice, then
Well,
I will
Commissioner Ngwetobi just reminded us, or did I misunderstand you, Commissioner Ngwetobi?
No, you didn't, Chief Justice. We
Yes.
debated Mr. Achoko's complaint in full.
Yes,
in-
yes,
In October 2023.
yes,
And we decided that it had no basis, it would not be put to the candidate.
yeah,
He then complained to the JSC. Justice Meyer delivered a judgment rejecting the complaint as unfounded.
yeah.
On this occasion, we again decided at the objections committee that the complaint had no merit.
Yes, no, I think,
It's completely unfair to put to this candidate.
I think we don't proceed with it, Commissioner Singh.
Thank you. Then you'll answer the first question, but I'll take the matter up later in discussions, Chief Justice.
Okay.
Yes, on the question of trust in the judiciary, obviously, it's a vital matter for the public. I think the way in which confidence in the judiciary is manifested is really threefold. The first is how are litigants treated in court and their representatives? Are they given fair hearings? They may be rigorous, but their cases are heard, and the judiciary is plainly on top of the materials and able to deal with the cases that come before them in a fair and rigorous way. That's the first thing. The second is that judgments are rendered in a well-reasoned fashion, particularly if a litigant has lost a case. They will be unhappy, but at least they should have the comfort of knowing that their case was properly considered, that the reasoning is sustainable, and that if they are still unhappy, there are places for them to go for other courts to have a look at it. And the third, of course, is when judgments come out. It's very important that the judiciary produce these judgments in reasonable time, so that we don't have a situation where people have to wait for years and years and years to have their matters disposed of at the courts. We achieve some of this some of the time, and we must always strive to try and achieve all of it as best we can.
Well, thank you. Would you agree, Judge, that confidence in the judiciary has been eroded because of these two historic findings or decisions by Parliament and the JCC?
Well, it's always very unfortunate that that these things should happen, but I believe the public has confidence in the judiciary as an institution. It's not a question of particular judges. It's how does the institution perform, and that is the cumulative effect of what I think more than 200 judges do every day, every month, and every year. And it's the cumulative force of that that contributes to what I think is still wide regard for the judiciary as an independent institution that has done considerably more good than harm in the last 30 years of our democratic order.
Well, thank you very much. Thank you, Chief Justice.
Thank you. Commissioner Makwanesh.
Well, thank you, Chief Justice. Good afternoon, Judge Unterhalter.
Good afternoon.
How will the years that you spent between 2006 and 2013 in the World Trade Organization be of help to the work of the Supreme Court of Appeal if you were to be appointed?
I'm sorry, I'm having a little bit of difficulty hearing, but you were asking whether what I contributed between 2006.
No, I was saying that the experience that you have been able to gather
Yes.
at the WTO,
Yes.
how do you think it will be of help? To the
Oh, I
work
see.
of the
I'm
Supreme
sorry, I
Court?
didn't hear the question. Yes. Well, I think there are really two ways in which that might be so. The first is that the appellate body is also an appellate let me not use the word court because that is controversial, but it's an appellate tribunal within the structure of the WTO. And so it has many of the same features as an appellate court. And I served there for many years, and so I had gained experience of what it means to operate in an appellate court and how courts of that kind operate. And the second is that although trade law is a specialized branch of international economic law, there are many principles of international law that suffuse international trade law. And since our Constitution gives a special privilege to the importance of international law, I think many of those principles are ones that I'm very familiar with and would help not only when there's a case directly involving international law, but also because of the regard our Constitution has for those principles and the benefit of understanding something, at least, of international law.
Thank you, CJ.
Thank you very much, Commissioner Jodovu. And on my list, that would be the last one. Commissioner Ngogaitogu will be the next one. Commissioner Jodovu.
Thank you very much, CJ. Good evening,
Good evening.
Justice.
Good evening.
As CJ prefaced his questions to you from the beginning, he said part of it was to say you came here several times to these interviews.
Yes.
What do you think that since the last interview that you were here and unsuccessful, what do you think are the improvements, better approaches that can persuade us to consider you this time around?
Well, I think you'll probably understand that after going through an interview process on a number of occasions, one has plenty of time to look back with hindsight at things and think about issues raised and so on, which I've obviously had occasion to do. And, you know, without going back through the issues that were raised with me, I think that part of this process is to understand what are the concerns of the Commission and how should one reflect on them, not in a hostile way, but simply to think about what these issues are and how they have arisen and what they mean. And I've done so, and if I may just let me mention one, which I think you may have raised with me last time we were here, which was the question of the error that I made in respect of the petition before the SCA and the Constitutional Court. We got into some very deep waters, and I'm sure I was a significant contributor to that. I recognize I made an error. I would much have wanted not to have made that error, and I would very much have wanted to have known that I was in a position where I had previously heard the case by way of petition in the SCA, because then I could have referred the matter to my colleagues to tell them what the problem was, and we would hopefully have worked something out together. So it's in that spirit that I return to say, you know, this is a learning process, and I've certainly learned some things along the way.
I might just say through you, Chief Justice, that for us, I think bygones is bygones. So whatever happened in the past is in the past, and we are here today. You applied, and we must give you a fresh opportunity. It cannot be double jeopardy. If that was the reason that we used to not appoint you, and I say if it was, it cannot be used this time around to consider your application. And you answered that you made some reflections about the past, and we are here. Let's move forward. Thank you, Chief Justice.
Thank you very much. Commissioner Ngogaitogu.
Thank you, Chief Justice. Judge Unterhalter, I just want to get some clarifications. What I've got from your CV is that you've been on the bench since 2018. Is that correct?
That's correct.
Which month?
I started in January.
Oh, it's January 2018. So that's around 5 years.
Yes.
And in that period, what I've got is that you delivered, I've counted 55 judgments in total. 20, I'm talking about reported judgments,
Yes.
not because I'm sure you've done so many other judgments.
Yeah.
Now, out of that, 22 are as a judge of the Supreme Court of Appeal,
That's correct.
and 7 as a judge of the Constitutional Court, and then 3 as a judge of the Competition Appeal Court, and 22 as a judge of the High Court.
I think those numbers seem about right.
Yes, which I mean, is a remarkable output of something like 10 reported judgments, well, 12 reported judgments every year.
I'll let the commission be the judge of that.
Thank you, Chief Justice.
Thank you very much. There are no further hands. Thank you. We have come to the end of this interview. Judge Unterhalter, once again, thank you for availing yourself. You are now excused.
Thank you, Chief Justice. Thank you, members of the commission.
Thank you.